First things first is, who needs a lawyer?
I guess kind of anyone who needs help. But what I'd say is that over the course of a musician's career, um, she's going to need help in a variety of ways. But sometimes the manager is able to help. Sometimes it might be a lawyer. Sometimes it might be a fellow artist. So not every time an artist gets an agreement, does she need to have a lawyer look at it. But a lawyer is one of the kinds of people who can review an agreement. I imagine, for some of the artists that a manager like yourself would work with, sometimes there are agreements which are very clear and, consistent with your expectations, and it just doesn't make sense to have a lawyer be involved. But for a much more intricate, long agreement that maybe the manager isn't too familiar with, the lawyer might get involved. So oftentimes a lawyer is like another member of the team and assists whenever the artist or the manager want the lawyer to give some feedback on a situation or an agreement.
Comes up often is we have artists that are very green. They don't necessarily have management, but they're seeking a lawyer because they have an offer on the table. When they're looking for a lawyer, can you give us any indication of what might be a red flag for a lawyer?
Yeah, I guess, not understanding the situation that you're in, preferably, I guess, every artist is a self-managed artist until they have someone else, as their manager. So, whether the manager is the artist or the manager is someone else, they might get a lawyer involved to help them to understand an agreement. But in terms of the red flags, if the lawyer is completely unaware of the type of deal that you're doing, that would be a red flag. You want someone who's dealt with these kinds of agreements before. Sometimes when I get asked to look at an agreement, I've actually seen like that same agreement before or something very similar from the same company. For example, I might review a record label agreement that an artist gets today, and I might have seen that same template agreement 6 months ago or a year ago. And so it's just kind of a simpler process to review it because I've already, reviewed that agreement before with a little bit of different information. But yeah, definitely a red flag is if the lawyer is not familiar with the specific circumstances that you're dealing with. And, preferably the lawyer says, like, this is not something I can help you with. And sometimes that happens to me. I mean, usually it's in an area that I'm not, like, for example, trademark. So I'm not a trademark lawyer. So every once in a while, an artist says, I want to trademark my name. And I say, great, I can't do that. But here's some people who are able to help. Have a look. If you want to be introduced, happy to do that. Or maybe it's about tax advice. Maybe they need an accountant. I deal with numbers all the time, but I'm not an accountant and I don't want to give, accounting advice. So preferably if the lawyer isn't someone who has experience on that specific issue, ideally they can help to find you the right person as opposed to pretending like they know what they're doing. So bottom line, a red flag would be if a lawyer is clearly not comfortable and experienced with the specific type of scenario that you're in.
And you bring up a good point there, mentioning, you deal with numbers, but it might be a situation where an accountant needs to come in. A lot of times I've seen artists as well expect their lawyer to negotiate and lobby. Is that something to be expected from a lawyer? Should that be something separate in your opinion?
It's all really combined. Definitely helping an artist to understand and negotiate a deal is definitely part of the process. And the context is that a lot of the value that a lawyer provides is to explain to the client or to talk to the client about what's normal and if what's being proposed is within the scope of what's normal or not. So that's something whereby, if a certain part of an agreement really is not very normal and very weird and very, not favorable for the artist, then what the lawyer would usually say is, this isn't how things should be. Here's what I suggest. Here's how I suggest we respond, regarding this point. And you multiply that by, all the elements in the agreement, and collectively the lawyer and the artist or the client put together a response to the other side. So, like, often, I mean, that kind of is a good segue to, like, what exactly is the process? If a lawyer is helping with an agreement, what normally happens is that the artist sends the lawyer the agreement. What I would do is I would say, well, what are your expectations of what's in this agreement? And I'll review it, knowing what you expect, and kind of knowing the players involved, and knowing who has leverage, and knowing, what other offers are on the table. And based on all of that information, and the more information, the better, I'll be able to provide my advice regarding how we collectively respond to this agreement that you're given. And, the next step might be that I prepare some edits to the agreement, or I might prepare an email that we send to the other people involved, outlining our position on the agreement. And generally speaking, it's to make the agreement more favorable for the artist than it otherwise was, to make the agreement more clear than it otherwise was, and to add in elements to the arrangement which weren't yet, contemplated or included in the agreement. So definitely, to your question, does a lawyer help with negotiation? For sure. But, the decision about what move to make is the artist's. So, like, I was on a call today with an artist regarding a certain situation, and I said, here's my perspective on this issue. What do you want to do? Like, think about it, sleep on it, take as long as you want. What I'll do is I'll send you an email with, like, the two different options for this specific issue, and then tell me how you want to respond. But what I can do is help you to figure out a couple of different options to respond to this issue.
Break it down for them. Here are your options in very basic terms. What do you want to do?
Yeah, exactly. Breaking things down, ensuring that people that let's say the artist, the client, understands everything about what they're getting into. I mean, some things are more important to understand than other things. Like, for example, well, really, I mean, you should understand everything, but you may not understand every single word. But sometimes, what a lawyer might do is to say, here's a summary of what this long paragraph is saying. And it really means like 5 words, like, you're covering them and they're covering you for things you do to each other. And that, like, indemnity clause might be, 400 words, but at the end of the day, like, that's what that means. And I think that that's reasonable in circumstances, or I think we should push back on this or that. But yeah, so really to make sure that anybody who's signing an agreement understands what they're being asked to do and being asked to agree to. Because if you don't understand, you're not able to make a decision about how you want to proceed with something.
Or you end up making the wrong decision. We see a lot of artists that unfortunately make the wrong decision, and you have TLC, Tony Braxton, where you end up having to do bankruptcy a few times to get back into the groove of things. And there are certain terms that I think I agree with you that artists should know off the top. And I want to touch base because, for artists that are tuning in today, that's what they're trying to look for, is these little pockets and little gems that'll help them in their day-to-day. So one of the biggest questions I always ask, what is a 360 deal?
Sure. A 360 deal is, so let's say that you're the artist and you're being offered a 360 deal. And you're an artist who, let's say, writes and performs your own music, or maybe you have, a co-writer or producer that you work with on your team. A 360 deal would be a deal with a company who wants to be involved in all facets of your business. The recordings that you create, the compositions you write, your touring, your merchandise, endorsements. They want to have a certain percentage of your child. Like, they want to have a piece of everything, relating to your life, or at least ideally to have the scope be more specific to entertainment activities or possibly music activities. But really, they want to be involved in everything. And the question is whether that kind of deal is reasonable. And I think that any deal is reasonable so long as it's reasonable, meaning that, like, if a company is willing to invest a lot in an artist, and by a lot, let's say, like, $1 million in a variety of things over the next while. They want to get you in the room with great people to produce with. They want to put a lot into marketing. They want to put a lot into radio promotion, into just a variety of things. And in return for that investment, they want to earn a certain percentage of everything that you earn, for a certain amount of time, for a certain amount of music. Well, that might be reasonable. But, like, the question is, well, who exactly here is the party or person investing in you? Are they the right fit for you and for your music? Are you going to feel, respected by them? Do they like you for your artistry, or are they just looking for somebody to kind of, fit in the outfit? So if there's a good fit in terms of the people that are involved, and they're making a substantial investment, and their entitlements to everything you do are like conditioned upon, or like are required, like they have to make that investment in order to get this percentage of everything you do, that might be reasonable. But if that same artist got approached by someone who has zero experience in the music industry, or maybe they won a Grammy in the 70s, like they just haven't, like not active right now, but think they are, and have no financial backing, and maybe you're in a lawsuit or two, if they provide a 360 offer, it's not exactly the same kind of 360 offer as, like, the well-funded, trusted company. So that's what a 360 deal is. It's a 360 because there's 360 degrees in a circle, and whichever way you pivot, they want to be able to have a percentage of it. And the question really is, what investment are they making? Are they the right fit for you? And, what are their entitlements? And if everything turns out great, is what they're getting reasonable? And if everything turns out, badly, are you able to get out at some point? So planning for success is important. Planning for potential failure is important. And planning for all the different scenarios is important. But a 360 deal isn't a bad word, but it only makes sense to enter into a 360 deal with the right partner under the right conditions.
Thing that you mentioned is the conditions. Always make sure you understand the conditions of your contract. The reason I say that is a lot of people don't realize that the deal you cut with a label or record company essentially is a loan. They are looking to recoup their money. And that's, I think, a lot of artists miss that point. They don't realize that, when the jewelry is given, when the fancy clothes are given, that's all a loan and you're going to get it back. So I think that's a very important point that you make. Make sure you understand your conditions, and that's when you want to really talk to a lawyer and have them explain to you thoroughly what the circumstance is of your contract before you sign possibly your life away. So another thing I want to talk about happening more often is licensing deals. Those get mentioned a lot to artists, and unfortunately, they don't necessarily know what that is. Can you explain to me what a licensing deal is?
Sure. I mean, there are different types of licensing deals. There's a licensing, possibly the one, that is most common that you're referring to is that if I'm an artist and I own, let's say, an album that I have made over the last year or two, and that hasn't gone online yet, it hasn't been distributed yet, I might give a record label the limited right to exploit this music, for example, for 5 years, all around the world, in all media. I still own the recording, but the record label has the exclusive right. They're the only ones who have the right, the permission, the consent, my blessing, to try to earn money from this recording, likely all around the world. Because everything is, or most things are digital these days. Oftentimes in a licensing deal, you're giving up the rights to have the music distributed around the world. The thing about, here in Canada is that if you get offered a licensing deal from a label that's not based in Canada, what you might want to do, or what I would probably suggest you do, is try to have Canada not be included, but rather have the rights to Canada be licensed by or be distributed by a company in Canada. And a reason for that includes music grant eligibility. You don't want to be in a situation whereby you could have possibly gotten a music grant to help to support the project, but you're no longer eligible because you have a non-Canadian distributing or licensing or owning your music in Canada. So it's important whenever you're considering an international licensing deal to talk to whoever's helping you with your music grants. And that might be yourself or your manager or a grant company. And you say to them, here's the offer I was given. What are some options regarding how we stay eligible for music grants? And that's the value that person on your team can provide regarding that licensing deal. Some other aspects of a licensing deal like this is that the amount of time that the deal lasts for is likely connected in one form or another to the label getting that loan repaid back to them that you had mentioned. So, if the label puts in, let's say, random number like $100,000 into marketing and distribution and recording costs, and the 5 years is up, but they haven't yet been reimbursed for that 100,000. Likely the deal keeps going until, at the very least, they've had their loan, paid back to them. There are other types of licensing within music. For example, licensing the right to have a song be put into a film or a TV show. Licensing comes up in samples. You might license the rights for a sample to be provided. At the end of the day, like the legal term of license is different from the legal term of assignment. License means to give someone a certain set of rights with certain limitations on it. So, for example, you're giving the rights to your music for a certain amount of time, a certain place in the world, a certain type of media that it's being distributed to. That's kind of compared with the concept of assigning. Assigning is giving entirely to somebody else. So if you're being asked to assign your rights in, let's say, an album that you've made, you are giving ownership of that album to the other company or person. In the case of licensing, it's a smaller commitment. It might still be a very large commitment. But there are some limitations to the rights that you're providing.
From a distribution deal, which is something that comes up a lot more these days.
Sorry, I missed part of the question. I just heard you say distribution deal.
That differ from a distribution deal, licensing versus distribution.
Oh, well, sorry, echo. In one sense, they're the exact same thing. I mean, it really, whether it's called distribution or licensing, it's like, okay, here's a related point. Whatever an agreement is called doesn't really matter. What matters is what's in the agreement. You could call the agreement the half glass of water on the edge of my desk agreement, and it can be about anything. I mean, so sometimes the words of licensing and distribution they end up meaning the same thing. They don't need to mean the same thing, but two licensing deals can look a lot different than two distribution deals. So at the end of the day, if you are licensing music or you are giving the rights for someone to distribute the music, what matters is how long they have the rights for, where in the world or the universe and beyond, they can try to exploit the music, what type of media, for example, physical versus digital, and also just, what their commitments are, what they're committing with respect to committing any kind of marketing money, any kind of recording money, any kind of resources at their company. So, whether it's called licensing or distribution, From my perspective, the key is, what actually is going on. And like just the other day, or I guess yesterday, a client emailed me and or he texted me a screenshot of an email from a label, which had some details about what the licensing deal would look like. And I said to him, well, what are they actually going to do? Like, are they committing to do anything? Are they committing to any marketing support, anything? And I mean, the answer was generally no. And I said to myself, or maybe to him too, like, this is a just trust me agreement. A just trust me agreement is an agreement, whether it's called licensing or distribution or like the glass of water on my desk agreement. It's an agreement whereby you are hoping for the best, because the other party, whether it's like a record label or whoever, they aren't committing to do anything, but you're hoping that they will. You're trusting that they will actually do what they're saying they're going to do. They will invest in you. They will like you. And they'll answer your calls and, invite you to their holiday party. So like, you're hoping for the best, but the agreement doesn't provide any obligations that they actually do anything. So what I always try to do is I try to move a just trust me agreement to an agreement that actually has specific obligations to the artist. Because if the agreement says, for example, that the label is going to invest, $10,000 in a marketing campaign, well, if they don't do that, but the agreement says that they're supposed to, then you potentially have a way out of that agreement to end it early if they don't do what they're supposed to do. But if the agreement doesn't require any obligations, and you're just hoping that they spend money on you, if they don't, you don't exactly have the same, ticket out of the agreement, out of that arrangement. So, this started with the question of, licensing versus distribution, and kind of, led to some comments about, how to kind of, keep other people to their word. But, that's kind of where that journey led us. So, the key thing from comments are, oh, sorry, go ahead.
I was just going to comment on the fact that I think the key thing you're saying here is don't get stuck on what it's called, be more focused on what's in the actual agreement. You mentioned, if they're saying they're going to spend $10,000 on marketing and they don't, that's your way out. If there's no clause and there's no agreement that says, oh, we have to do this, you might be stuck. And that's where you see artists that are getting shelved and sitting at a label for years and can't do anything because they don't have a way out either. So getting in is important, but equally being able to get out is important. It's almost like this risk management.
Agreed.
The next thing that I get asked all the time, this was actually submitted to us from someone, is how do I copyright a song?
So how do you copyright a song? So if you have an idea in your mind for a song, that's not protected by copyright. Once you write the song down or record it, or make a voice note or some other way of that song being in a tangible form, that song now is protected by copyright. So you don't have to actually register it with the Canadian Intellectual Property Office in order to get copyright protection. However, if you do register it with the Canadian Intellectual Property Office in Canada, or the United States Copyright Office in the United States, that provides you some additional protections in the context generally of someone suing you or you wanting to sue somebody else, because you're taking the position that they're taking the position that you stole their song. In those situations, it's helpful to have a song registered with the Canadian Intellectual Property Office, because it creates a presumption legally that you were the creator when you said you were. But you don't need to do that in order to get copyright protection in a song or a movie script or a poem or a visual art piece. It's all about it being in a tangible form.
Sounds very simple when it's one person. Let's say I make the beat, I make the melody, I write the lyrics. What happens when you're now making it with a group of people? It's a collective effort. How does that change how copyright works and royalties and splits?
So, that's a 2 hour answer. That's a question that has a 2 hour answer, but in kind of a few sentences or less, what I would say is that if an artist is working, if a singer songwriter is working with another writer, then before, during, or after they've written the composition together, it's a good idea for them to clarify their respective entitlements of the composition. For example, that it's 50-50 or 60-40 or whatever they want to do. And one way to formalize that split is through a split sheet. And I'm happy to send a split sheet to kind of anybody who asks by email. But a split sheet at its core sets out what the percentage of ownership is for each of the people who are involved. And it might be a co-writer, it might be a producer, it might be a featured artist, it might be someone who's just in the room creating a vibe, or a beat maker, or the writer of a sample, the writers of the song being sampled. So there's a variety of people who might collectively have their interests add up to 100% of a song, of a composition. So it's really important when you're working with someone to create something like a composition that you figure out at some point, preferably earlier than later, what everybody's entitlements are to that song, like what the splits are of that song. And kind of taking it to a second stage, it might be that one of the people involved controls the composition. So either everybody on their own controls their share of the composition, or perhaps one person involved controls it. So for example, if you and I were writing a song together and I'm the artist and you're my co-writer, we might agree that I control this composition, but that you're still being entitled to receive 50% or some other percent of the royalties generated from this composition.
Brings me to my next question. Is doing a verbal agreement enough?
So a verbal agreement is an agreement, just like a written agreement. They're both agreements. The challenge with verbal agreements, among other things, is that when people discuss things verbally, sometimes they forget. It's easy to lie about what was in a verbal agreement. And I mean, I don't know what I had for dinner yesterday, let alone what the splits were on a song that I wrote 4 years ago, that I haven't used but want to use now. So people just forget about stuff, and so it's just a lot easier in general. I should have wrote down my grocery list because I forgot all the things I went to the grocery store to buy. So it's good to keep things written down for that reason, because it's just nice to have things organized that way. But also, with respect to Canadian law, when you're transferring intellectual property, it needs to be in writing for it to be legally enforceable. So there are a variety of practical and legal reasons to get things in writing. That doesn't make a general verbal agreement invalid, but there are reasons why it makes a lot of sense to get things in writing. And by in writing, I don't mean it has to be a lawyer who adds their fancy notary stamp to make it legal. Having something in writing with your creative collaborator can be by text, it can be by instant messenger message, it can be by whatever you want. So in writing doesn't have to be a formal agreement signed with nice feather pens. It can be done digitally. It can be done in a variety of ways to have it be in writing. The other kind of practical advantage of a written agreement versus a verbal agreement in general is that it likely includes more details than what would be in a verbal agreement. So for example, for a management agreement might be several pages of information about how commission is defined and what the sunset clause is, if there is one, and what the scope of certain revenues are that are not counted towards commission. A lot of really interesting stuff, or interesting at least for me. If you have a verbal agreement between a manager and an artist, it might just be that the manager is getting 20% and that's it, and like no other details. So the value in a written agreement is that there's likely more stuff there that the parties are agreeing to versus in a verbal situation. However,
The 20%, it's the 20% of what is the next question, right?
Exactly.
So that's
Exactly.
what need to come
Exactly.
in.
To come in.
So even an email is better than just verbal.
Oh yeah, but the thing about verbal is that what I kind of say to anybody, who will listen about it, like you don't want to just present somebody with a contract. You want to talk to them first about what your agreement would say. So if someone's a manager who's been working with an artist, the manager, I don't think shouldn't just kind of send an agreement out of nowhere. They should have a meeting with the artist to talk about, okay, what are your expectations of me? What are my expectations of you? Are we both comfortable with this? How do we define success? All that fun stuff. Like it's important to have a verbal discussion before you put pen to paper or fingers to like keyboard, or hire a lawyer to help with an agreement. You want to make sure that you're having a discussion with the people you're working with. I mean, that's more kind of that's more relevant for like a manager agreement as opposed to a split sheet. But it's, even a split sheet, you want to talk to people. You say to them, okay, what does everybody think? How does everybody think we should split up this composition, as opposed to just, giving somebody something to sign? So, verbal is good, but, finish it off with something in writing, or, something that's, written down in either a digital way or something on paper.
It's date stamped. That's the important part. The date stamp on there.
Yeah, and the date can be a long time ago too. The date doesn't have to be today. If you and I started working together today, and you were my manager as of January 1st, 2021, we can date the agreement as of January 1st, 2021. You're allowed. There's nothing stopping us from dating an agreement before or during or after the day that we sign it.
We talked about red flags earlier for a lawyer, and right now that is a point that I want to make for anybody watching. If you are with management and the first thing they do is put an agreement and they want you to sign day one, that to me as a manager is a huge red flag. As a manager, you're building a relationship with an artist and making sure that you guys work well together. So if you're an artist and someone just comes out of the woodwork and wants to get you to sign off on paperwork day one, run the other way, because I almost guarantee you it's not going to work out. So always make sure your relationship is working well before you start getting into those legal documents and signing off and whatnot. So that would be, as a little side note, a red flag for anybody out there who's looking for management. Make sure that you work well together before and have those discussions, so that when you do go to sign papers, there's nothing in there that's new. It's nothing surprising. So that's a little side note there. What's a common mistake that you see artists do?
Well, similar point. Trusting people. So trusting the wrong people, assuming that people's promise always be kept. Yeah. Unfortunately. Yeah. So common mistakes. Apart from the whole trusting thing, is that you assume that. So someone says to you, here's what's in this agreement. They're kind of telling you what's in an agreement, and they just ask you to sign. And the common mistake is that what you're being asked to sign is consistent with what you were being told. So, that kind of goes to, I think, an earlier comment I made, that whenever I'm reviewing an agreement, one of my first questions is to say, what do you expect to be in here? What were you told would be in this agreement? Is there an email chain? Is there a conversation? The more I know about what you expect to be in here, the better I can advise about whether that's actually in the agreement. And sometimes it's not there because someone's lazy. Sometimes it's not there because they're trying to, screw you over. And sometimes it's not there by mistake. So just because the agreement is inconsistent, a little bit, doesn't mean that someone's shady. It might mean that just someone made a mistake along the way, like an error in preparing the agreement. But still, definitely a common mistake is assuming anything, including, what's in an agreement. Just assuming that, well, this manager did a great job for somebody else, they're gonna spend the same kind of time on me, or assuming that this label, they have this one really big star, so they're gonna, invest in me to become the next one. So really just assuming anything is generally, I mean, in life too, but also, with respect to music law and music agreements and relationships, assuming anything is a common challenge that I help artists to overcome, or at least I.
That's a good point. The signing to a label because they have a big artist, they're going to do the same with me. Each artist is different. Each deal is going to be different. So always make sure you're looking at your deal because it's tailored. It should be tailored to you. And if it's not, that's also another discussion to be having with a lawyer.
If they put the wrong name in the agreement, or they, if it's for anyway, yeah. So sometimes there's just kind of some funny errors, but definitely, all mistakes should be cleaned up. Yeah, agreed.
Kind of getting into, the deals and starting to make waves and moving on to, almost like the second phase of their career. What can they expect in regards to costs? There is a huge assumption that the cost for a lawyer is astronomical. Can you kind of touch base on what to expect price-wise for certain services or hourly, et cetera?
Sure. For our firm anyway, there's two different ways that we charge fees. One is on a fixed fee basis, like if we're being asked to prepare a certain agreement between our client and somebody else, what we would try to do is say, well, here's the specific fee we would charge to do this. Do you want us to do it? But most of the time, we charge based on our time, and we keep track of kind of every moment of the day, which is sometimes quite annoying, but it's just something that is kind of part of the day of keeping track of time. And yeah, so most lawyers charge an hourly rate for their services. At our law firm, we have 6 lawyers, and the rates range from $225 to $425. I'm kind of in between, sort of. And I mean, it really depends on the circumstances of like, okay, I'll kind of come at it a different way. So if I get asked to review an agreement, what I would say about cost is probably the first phase of me being involved is that I'm going to read the agreement and have a discussion with you about, my kind of key concerns about this agreement. And maybe it'll take me, half an hour to read the agreement, and maybe we'll have a half an hour call. And, that's an hour of time. And that may be all I ever do. Or you might want me to stay involved and prepare some edits to this agreement, or jump in and, communicate with the other side directly. But, phase 1 of a new agreement is likely me just reading it and having a conversation with you to answer your questions and to point out things that are really ridiculous, as opposed to stuff that's like, not that much of a concern, but really kind of focus on the key challenges. And so, it's really important for any kind of service that someone has, or is buying, that they understand what they're getting, and they're getting value, but that they're really clear from the start about, what the cost will be. The challenge with legal fees and negotiations are that you really have no idea how long something will take to get negotiated. And sometimes deals get done in a day, and sometimes deals get done in months. And ironically, if a deal gets done in a day, it might be that everybody involved spent, 7 hours on this thing back and forth the entire day working on it. But the deal that took 3 months was actually only 10 minutes here, 20 minutes a month later, waiting for comments. It may actually take a lot less, legal service time, but it could take, 3-4 months to get done. So, you're kind of balancing those different situations. And oftentimes, we can't control how fast or slow the other side is going to be. You always want to try to get things done quickly, but if you're dealing with a record label who has 20 artists that they're actively working with, and 10 more that they're hoping to sign in the next year or so, and you're one of those people, you're kind of a low priority for them. Like for you, this record label is the biggest thing in your life right now, but for the label, you're kind of on the back burner, and yeah, they'll get to it when they have time for it. So I know I'm kind of talking about some different stuff, but you want to just have kind of clear understanding and expectations of how long agreements take to get signed and done, because it usually is a lot longer than what you'd expect. And it's not fun kind of waiting for an email to come in or waiting for a phone call with news. It can be extremely frustrating. All that to say, so in terms of legal fees, what you want to do is you want to communicate with your lawyer, proactively, to say, here's my budget. And maybe, if someone's budget is like enough to spend, 2 hours with the lawyer for this agreement, it's important to discuss, what can be done in that time and what can't be done in that time. And, I think at the very least, having a lawyer review an agreement or review some deal points and talk to you about it, like that first hour of time or so, is extremely valuable. And if that's what you can afford, great. Like that's still a lot of value that you can get out of a lawyer, even if you can't afford to have the lawyer kind of be involved throughout the entire process. Having some initial feedback about the overall deal can definitely go a long way.
I think key points that I want to summarize from what you just said, for me as a manager, I always include a budget for a lawyer. And that's one thing that I would suggest for artists, to make sure that you have a budget and be realistic about it, right? Understand that it's also very important for you to invest in a lawyer, because it is going to help you in a lot of ways. I think a big thing that you mentioned is make sure that you have almost like an agenda for that first meeting, so that you're not just kind of feeling it out, because it is costing you by the minute. So go in with an agenda, and that one first hour, 2 hours is going to be very useful for you as an artist. So my big takeaway for that I do preach with my artists is, don't look for the in and out kind of lawyer that's just going to be like, oh, here's $50 an hour, I'll do it quickly for you. That's not always the best case. The fast food lawyers, as I would like to call them, they're not the best options all the time. So go do your research, make sure you look for the right person, make sure you have a budget. It's equally important that you have great producers, but it's also very important to have great lawyers and business managers on the other end. So make sure you invest in both of them as well. We're kind of wrapping up here. Is there anything, last minute advice you'd love to give our viewers today?
I mean, some kind of like some taglines that I sometimes use, but that have a lot of meaning, are to plan for success. And I talk about that, in maybe one or two contexts. Something that I talk about sometimes is the following 9 words. What are your expectations of me and my music? And that's kind of a good, like, break the ice type thing for creative collaborators among each other, because some of these conversations that we're talking about can be quite awkward. If you're talking about, sharing potential revenue, sharing rights, that kind of stuff. But, you want to be, if you can be proactive with your creative collaborators, then, you can get the business stuff out of the way and focus on, the creative. And, that's something that I, kind of promote whenever I can, just to kind of have, start that conversation, get it done and over with, and then, not worry about it afterwards. One other thing, we're talking about like assumptions and, making assumptions about stuff, and the related type of issue relating to assumptions is about samples. And, there's a lot of samples in music, in a variety of different, types of music. And, the assumption that if I'm using someone's sample, they'll be like honored by my use of this sample is not a great assumption to make. I help clients with sample clearances a lot, and just kind of dealing with the issues of samples. And at the end of the day, like just a kind of a key takeaway about samples is that if you want to sample someone's music, you need the right to use the original recording and the original composition. And it's not that difficult to kind of, find out who actually has control. Oftentimes they won't respond to you, but just thinking about that process, if you want to sample anybody's music in any kind of way, is that you do actually need permission. You're generally going to pay less if you're asking for permission as opposed to asking for forgiveness later on when they catch you. But, if you're sampling a song and kind of assuming that, the song probably won't go anywhere, everything will be fine. If this song turns into the biggest thing you've ever done and the biggest song of your entire career, and it has some little sample in it, well, you've just probably given away most of the money that song will ever, generate for you. Whereas if you had got permission, originally, then you wouldn't be giving away so much later on. So, those kind of issues do relate to each other in the concept of planning for success. So, any song that you work on, it's important to figure out who's involved, what everybody's entitled to. If there's a sample, get it cleared. If you can't clear it, don't use the sample. I'm not the sample police, but you don't want to be in a situation where this massive song has this sample that's not cleared and now nobody wants to touch the song, or they're afraid of it because it has this sample that wasn't, didn't get permission to be used. So, those are some overriding concepts that I think are really important. But, I'll save the best for last, or the most important, and we've kind of talked about it, in a few different ways. But the most important thing is working with the right people, management especially. Like having a mediocre agreement with a great manager is much better than having like a great agreement with a mediocre manager. You want to be working with the right people who, are on the same page as you regarding how you define success and your vision and your way to get there. And, it's so important to work with the right people and the right companies and the right creative collaborators, much more important than, a few percent here, a few percent there, or, some clauses in the agreement that aren't really so good for you, way more important than all that stuff. Although that stuff's important, but the biggest thing of all is who is signing this agreement, with you, who's the other party involved, because that will likely be the most influential part of, having your career stall or having your career go to the next level.
Those are great points. I really like that last one as well. And quickly, in our last couple minutes, how can someone get in touch with you?
For sure. Well, the kind of the handle for the firm is Edwards Creative Law. My email is byron.pascoe@edwardscreativelaw. But if you find us on Facebook or Instagram or LinkedIn, Edwards Creative Law is how to find us. And I'm happy to answer other people's questions and things. Like what I usually do is I say, so long as you've like signed up with SOCAN or you've now registered with a new collection organization, like I want you to take that step before I kind of answer some free questions about stuff, because I want to, encourage you to be a member of the societies that represent us. So like I was at a music studio the other week, and I said, like, is anybody here a member of SOCAN? And none of them. So I said, I'm happy to answer your questions so long as you, become a member. So anyway, that's my rant about those organizations. But I'm happy to have a conversation with anybody about their situation. We do kind of, free intro, get to know you discussions with anybody. Happy to have them with people who are watching. That's how you find us, Edwards Creative Law. Find us on the social platforms.
Awesome. Thank you so much for taking the time today, giving us some knowledge, some gems there. So again, they can find you at your email. They can look you up on Facebook, Instagram at the handle. So thank you so much, Byron, for being with us this evening.
Thanks for having me.
Our viewers concludes our first one. Thank you so much for coming and tuning into Latin Week, presented by Latinx Nation. And of course, I am your host, Marcella J. Make sure you hit me up on Instagram at Hey Marcella J.